So, is this working? Yes. Okay. Well, if I had known that what I was going to say actually, in some ways, I don't think it overlaps with Emma's presentation, but I'm actually, thank you, Emma, for introducing what I'm going to say, and thank you for giving me the opportunity to have a conversation with you up here. So I didn't ask any questions for once, because I thought that I knew I would have, oh, thank you. I knew I would have the opportunity to share with you some of my thoughts here. So the formal title of this presentation is Business and Human Rights Between Law, Politics and the Economy, but I thought it might make it more meaningful for you if I gave it a subtitle, which is What CSR Got to Do with Public Participation and FPIC. So that's what I'm going to try to explain to you. So the thing here is that you'll find me saying a lot about corporate social responsibility. You'll find me saying a lot about business and human rights, and it all sort of comes together to how public participation and FPIC can be promoted if we think carefully and different actors think carefully about all the different interests that are at stake, from regulators, from policymakers, and from economic actors. Now, first of all, when I say corporate social responsibility or CSR, you might think, what's that got to do at all with what we're talking about today? What's it got to do with a conversation that so far has been really, really strongly referring to legal standards? Because CSR is often understood to be something that's voluntary. The reaction that I very often get is, well, because CSR is voluntary, then law has nothing to do with CSR, no CSR at all. And for those who work with CSR, looking at anything legal is not meaningful. Also, CSR is a very contested term. It has helped put various issues on social, environmental, sustainability onto corporate agendas. For example, we talk about the term license to operate, sustainable supply chain management. We have the triple bottom line, people, planet, profit. We have corporate philanthropy. But others will say it's just about greenwashing or blue washing for companies that are members of the UN Global Compact, because the UN flag is blue. Window dressing or self-serving rhetoric on the side of companies. I think it can be both. There can be both elements, definitely. But what I'm going to try to argue here is that for corporations, many of whom in the extractive sector have CSR policies, recognizing that they do have those policies and leveraging their commitments to social, environmental, climate change, sustainability, because they have their policies, can be a way for governments to make it very clear to companies that they have to walk their own talk. So that basically means that policymakers or lawmakers can leverage the commitment of corporations to do less harm or do no harm, and also to do more good, by explicitly addressing the commitment they have made from the economic perspective. This can also mean that they have that regulators, public organizations, whether at the central or local level, will sometimes need to refer to the social license to operate, because that is a language that companies understand. When I really attach so much emphasis to this, and also to using these contested terms, because they actually make sense to companies, because companies use them. I do this because I conducted a major study looking into the evolution of actually business and human rights, a sort of emerging regime that's related to CSR but also goes beyond that. Looking at the different efforts and looking at what were the arguments that were successful in generating support, and what were those that were not effective in generating support. And it was very, very clear that when policymakers or regulators or those who are charged with developing new norms for business address businesses in a way that activates their economic rationality, then they start to listen. So if you can talk to them about something about being risk management or social license to operate, or you can explain to them that not paying attention to social expectations or public policy objectives can actually cost them money, whether it means that they don't get a concession, or whether it means that they lose income, or whether it means that they're even subject to claim some compensation, then they will start listening. And I guess vice versa, if companies want to talk to policymakers, they can use the same strategy, but they're really good at that already. So right now, what I want to focus on is, if from the governmental perspective, from a relatively small country in terms of population, like Greenland, with a huge territory, what are some of the arguments that this government can think of in order to leverage this social commitment of corporations? And this then brings me back to CSR and the fact that CSR is not just about not law. It's not just non-law. If we look at the legal theory, and so of course this is some of the formal stuff I have to say because there are academics around. So I have to say there are some legal theories that endorse the connection between CSR and law. For example, we have both some sort of theory going back to the 1990s, talking about social reporting, or what we refer to today as CSR reporting, as having the potential to promote and stimulate self-regulation within corporations. We have newer theory talking about how governments can proactively shape business conduct, also through referring to applying the term CSR. Actually, incidentally, I just read in the newspaper yesterday on the flight here that Greenland is now in the process of implementing the CSR reporting and the mandatory CSR reporting requirement that was introduced in Denmark in 2008 with effect from 2009, apparently as part of the revision of the company law. Now, what's interesting from that perspective is that if we look at the legal history of the Danish CSR reporting requirement, which is now going to be part of Greenlandic law for companies, that very, very clearly shows that the intention from the government, the Danish government for Danish companies, was to stimulate corporate stakeholder engagement or company stakeholder engagement for companies to better understand about how society, whether we talk about individuals, whether we talk about investors, whether we talk about governments, understand and are concerned with the impact of companies on society. And the better they understand that, the better they can self-regulate to change their procedures, their practices in a way that does not cause harm and contributes more to society. Now, for various reasons, which I hope Greenland is not going to repeat, that message got completely lost in Denmark. So partly because the Danish government was very bad at communicating to society, including the media, that this was about stimulating corporate learning. This was not just about producing reports that nobody reads and then forget about it, let's get on with making business, and forget about our corporate responsibilities and impacts. It's about mandatory CSR reporting. Sorry, I thought I said that. Mandatory CSR reporting. Sorry? Okay, without knowing all the details of the Greenlandic version, but I assume it's the same as the Danish one. Companies are required to report on their impact on human rights, social issues, environment, anti-corruption, and climate change. Now, those of you who may be familiar with the UN Global Compact will recognize that the first 4 issues all correspond to the Global Compact issue areas: human rights, labor issues, environment, and anti-corruption. The 5th issue, climate change, is aligned with a particular sort of campaign under the Global Compact called Caring for Climate. Now, when I say Global Compact, is that sort of a, as we say in Danish, a city in Russia for everyone? Or does it sort of ring bells with everyone? Most people? Okay. So basically that's what companies are supposed to report on. And then the point here is that really goes back to this idea of CSR, non-financial reporting, stimulating corporate responsibility. So the point is that CSR actually does have something to do with law. If we look at some other aspects of the organizational literature, one of the sort of gurus in organizational CSR literature, Archie Carroll, who's very often referenced by organizational scholars writing about CSR, actually explicitly, all the way back in 1979, said there can be no CSR without legal compliance. So companies cannot go around claiming they are socially responsible if they do not also observe the law. And in a more recent version, Carroll, with one of his colleagues, said this also means that they have to observe the spirit of the law. So companies cannot go around claiming to be socially responsible if they exploit governance gaps. So if we look at, for example, the Rana Plaza collapse in 2013, which was caused, well, by a number of factors, but definitely brought it home to a lot of people living in the West, that the fast fashion clothes that we like to buy, they are produced in a way that makes them cheap, because conditions in Bangladesh, in the Bangladesh textile sector, does not compare with the conditions in much of the West in regard to salaries and occupational health and safety and building safety, right? Why is that? That is because on the Bangladeshi side, the institutional structure to ensure building safety does not compare with most of what is like in most of the West, right? So this is a governance gap. The rules are there in principles. If you go and check the rules for building safety in Bangladesh, they're actually okay. If you go and check the rules on child labor, they're actually okay. If you check the rules on occupational health and safety, they're actually okay. If you check the way they work in practice, it's not okay. So this is a governance gap. It makes it much easier for companies, including a Danish-based company that sourced from the Rana Plaza building, to produce goods cheaply, because they can say, well, the law is in place. Of course we observe the law, but when it comes to practice, then it's so easy to produce cheaply because the law is not being implemented. So that's not observing the spirit of the law. What we've also seen is a more recent trend in which human rights as such has become a defining force for actually changing the idea, the understanding of CSR. Now, business impact on human rights has been a major aspect of social CSR for many years. Thinking impact on communities, several people here have talked about the impact of the mining industry on communities, but we can also talk about other forms of natural resource exploitation, agribusiness, fisheries, or the case that Emma also referred to, which I think is the same one as I'm going to refer to, the Jinjavari Sami village. Is that the one? I don't speak Samish. Yeah. About the project to develop a wind farm, infringing on the practice of the reindeer herders, right? So we've got it all around. Now, if we look at a bit of history here, there's been several efforts within the United Nations to develop normative guidance for businesses on human rights. The basic reasoning is that the United Nations, which is the world's organization for promoting not just peace, but also socio-economic growth and human rights, with the growth of business enterprises becoming as huge as it is today, and the political power becoming as huge as it is today, it's really hard for the UN to deliver on its objectives if businesses are not involved into the implementation. And under international law, business corporations have no place. So they have no obligations. When you have no obligations, it's really, really easy to go around and do as you want and then avoid any sort of responsibility or legal liability. And with business activities also becoming increasingly transnational, it's also very easy for a company to have its home country in one place and then operate in another. And then if something happens, well, So sorry, you know, if the Bangladeshi government or victims of the Rana Plaza disaster want to pursue a Danish company, they would have to probably start a court case in Copenhagen, Court of Copenhagen or Court of Aalborg for a Danish company. How would these people do that? So there are too many there are too many opportunities for impunity for corporations. So the idea was try to do something about that. Now several efforts failed, but in 2005. A process was launched that led to this UN framework, which was elaborated into what Emma also referred to. Emma had a really nice picture. I don't have the picture, but the nice little pamphlet that Emma had on her slide with a nice little UN thing with lots of human faces and smiling people. That's how the UN likes to portray the world. That is the little pamphlet on the UN Guiding Principles on Business and Human Rights that you can download. That succeeded, and the UN framework, which was more of a policy instrument, succeeded. And why did these two succeed? Well, there were a number of reasons, but one of them was that the process was led by a person who really managed this this strategy of arguing why businesses should respect human rights in a manner that touched directly to the interest of companies. So he spoke about the social license to operate as part of the reasoning why corporations should take their human rights impact seriously. And because what had happened during the previous efforts was that international lawyers and other lawyers and policymakers and civil society organizations had been talking the international human rights language to corporations. And corporations would then say, hey, human rights, that's international law, we know that that's obligations for states. If it's about rights, we call in our corporate lawyers, and the corporate lawyers were trained like I was, and I'm sure Rachel was, to know and to say and to argue that international law is obligations for states. So if somebody turns up and says, hey, human rights obligations, this is something you should pay attention to as a company, the logical reply from the corporate lawyer will be, no, this is rubbish. You're mixing things up. You're trying to transfer state obligations onto companies. This is bullshit at best. You know, let's get on with having a conversation based on states' obligations, states having obligations for certain things, and then corporations making money so society can keep going around. So it was really a very important step forward. And the other thing, which also Emma mentioned, was that the UN Guiding Principles and UN Framework explicate the connection between the roles of governments and firms. Now, before, this had also been seen as something distinct. But what the UN Framework and the UN Guiding Principles do is they say these are really interconnected. And this brings me back then to PP and FPIC. One of the things I have to say before that is that the UN Guiding Principles have had really strong influence on several hybrids, so public-private CSR schemes with more or less global applicability. The UN Global Compact, I already mentioned. The ISO 26000 social responsibility guidance, which is, like any other instrument, is an ISO standard that companies can say, we will use this to help us do what we should in a particular area. So the SR is for social responsibility. It's not CSR because it's intended also to apply to civil society organizations and governments if they like. And OECD's guidelines for multinational enterprises. Which I'll be saying a lot more about. Because OECD's guidelines for multinational enterprises is one of the key texts that have further elaborated the key points of the UN Guiding Principles, especially due diligence and meaningful stakeholder engagement that also Emma talked about. Why is it that the OECD guidelines are so important in this respect? They are because the UN framework and the UN Guiding Principles were developed under strict UN rules, which means that the report has to be confined to 30 pages. Now, if you want to deal with something that's as complex as the relationship between businesses and human rights and what states should do and what companies should do and fit that into 30 pages, and you have to have all the formal UN stuff in there also that just have to go into report, you can imagine that it has to be very, very, very much actually just in basics, but at the same time, of course, then inviting other organizations to do more elaboration. And the OECD did that in its 2011 revision of its guidelines. Now also, the EU revised the CSR communication, which is a policy instrument, but in 2011. But what the EU did was, based on the influence of the UN Guiding Principles, it deleted any reference to CSR being voluntary. So before this, and this was interesting because we actually don't have any definition in the literature of what CSR is. Not any specific definitions. We've got probably as many definitions as we have scholars working on CSR, so that's a lot. But for some reason, the EU definition, despite the EU being an international organization, a regional organization on trade, has become really, really influential in the literature. And the EU used to define CSR as voluntary action by companies above the law in regard to their social and environmental responsibility. So when the EU did away with the reference to CSR being voluntary, all of a sudden it opened up opportunities and recognition of the fact that governments, whether they're the EU, member states, the EU as an organization, or any other government, in fact, can actually very actively try to regulate what companies are doing in all sorts of ways in order to shape their action to do less harm and do more good. For example, the EU has also adopted this risk-based due diligence that Emma also mentioned as one of the issues that companies have to report on. And I think, again, without knowing, I think Greenlandic companies will have to report on that also, because that is also now part of the Danish CSR reporting requirement. And the Danish CSR reporting requirement, which Greenland is implementing, it goes much, much beyond the quite limited scope of companies or types of companies that are subject to reporting under the EU directive. So under the Danish law, Financial Statement Act, quite a lot of companies actually have to make these CSR reports. And again, without knowing the details, I think it will be probably quite a large number of Greenlandic companies, definitely most of the large ones. And of course, also the UN Guiding Principles have also already had a lot of influence in corporate policies for CSR, including the extractive sectors. But again, I will sort of keep this the governmental focus. So I'm not going to look so much at what corporations have been doing. The business and human rights regime, which I refer to as a regime because it's really a sub-issue that within international human rights law, because it recognizes that corporations have responsibilities for human rights, even if this is on a soft law basis, not enforceable. But if we think about international law usually isn't enforceable. So whether something is hard law or soft law doesn't really matter so much, because as long as we're not talking about international trade law, enforceability is basically left to nice intentions in committees that can at the most point a finger and say, don't do this again. So they rest on three pillars: the state duty to protect, which means for the state to protect against human rights abuse caused by third parties. So the state has to regulate the relationship between individuals and corporations at the horizontal level. This is different from normally when we think about human rights in the state. The state respects the rights of the individual, so it's a vertical level. The corporate responsibility to respect, which applies to all companies regardless of form, and which actually has a dual element to it, which is often overlooked in the debate because it comes out more clearly in the UN framework. One aspect is compliance with applicable national law in countries of operation. This is the thing that's often overlooked. The other thing is that corporations should self-regulate to conform with international human rights law where national law and its enforcement is not adequate or not in accordance with international law. And then jointly to ensure increased access to remedy. And this access to remedy takes several forms. The state-based, there are of course the courts, but also non-judicial remedies like national human rights institutions, including in principle, I guess the one for Greenland, and national contact points, which are a special remedy institution established under OECD's guidelines. So I get back to the guidelines. And then, of course, at the operational level, also corporations should establish company-based grievance mechanisms, which I'm not going to be saying any more about. What I do want to say something about is the fact also that, according to the UN framework, the minimum baseline for corporate responsibility to respect is the International Bill of Rights and ILO core labor standards. And when I say the International Bill of Rights, I would like to refer to Rachel's slides with a long list of the provisions of standards from the ICCPR, the International International Covenant on Civil and Political Rights, and the ICSCR, the International Covenant on Economic, Social and Cultural Rights. These are the International Bill of Rights, along with the Universal Declaration of Human Rights. So companies should observe those standards, including the interpretation, the understanding of the provisions that refer to popular participation and FPIC. So it's actually there's already a lot of richness in there that I think so far has not been dealt with very much in the literature, but maybe a bit more in practice. And of course, companies don't have to just follow the minimum. There's plenty of scope for including further instruments. For example, ILO Convention 169, which is not part of the International Bill of Rights and not part of the ILO core level standards, but why not go ahead and look at more? Companies should also exercise risk-based due diligence. And Emma said a lot about due diligence. I would like to take this opportunity to really highlight that this due diligence is very different from what lawyers are used to thinking about with due diligence. Lawyers, especially corporate lawyers, think about due diligence being an exercise to identify and manage risk to the company from society. Risk-based due diligence take another perspective. It's about identifying and managing adverse impacts to society caused by the company. So see, it's completely the inverse. And if we don't pay attention to the fact that these are two very, very different approaches to due diligence, many of the actors we talk to are going to be very confused because they're really expecting something else. And of course, as Mema also says, stakeholder engagement and communication forms part of it of this due diligence, and this includes communication with affected stakeholders. One of the things that is happening with this increasing focus on non-financial reporting, including at least the Danish version and implementation of the CSR reporting requirement, is that a lot of people are just thinking about the report and, the ex post thing. Once we did something, we carried out a due diligence exercise, we maybe caused some harm, maybe we didn't, then we write a report, and then we really focus on the report, rather than thinking, hey, we carry out due diligence because we want to identify, prevent, and mitigate harm before it occurs. We use the reporting process as a way to engage with stakeholders and better understand how they see our impact. And that way we can actually also self-regulate to avoid causing harm. That's one of the big risks, I think, with the current reporting focus, but I just took the opportunity to share this with you. Now, I mentioned OECD's guidelines for multinational enterprises. Very briefly, this is a soft law instrument that was adopted by the OECD in 1976. It was revised in 2011 to ensure coherence with the UN guiding principles, including by adopting the risk-based due diligence approach, and not just applying it to human rights, but also to labor, to environment, to consumer concerns, several other issues. Now, the OECD guidelines are soft law. They're not binding on companies, but they can be enforced through these national contact points. The national contact points, they're non-judicial remedy institutions, meaning they cannot issue a legally binding judgment, but they can issue critique of companies. And the other thing is that NCPs have extraterritorial powers. This is really unique when we talk about the social impact of corporations, that a remedy institution can consider the impact of a transnational company for something that happened in another country. We have similar institutions, similar things can be done with courts. But the problem is very often when we have a court process that it becomes very difficult for the people who are the victims in a faraway country to launch a case and really manage to argue their case with a court in the home country of that company. So the strength of the NCPs is that even though they cannot issue legally binding statements, they can definitely issue critique, and they can do that in a manner that relates to action that occurred far from the home country. Just to give an example, the Danish NCP, exactly a year ago, actually to the date, issued a statement in which it very much criticized the due diligence process of a Danish textile company that sourced from the Rana Plaza building. So a Danish court could not have dealt with this. But what happened was that this was actually a relatively small textile company, but it's still multinational because it produces in Bangladesh. It runs several sort of not very pricey Danish textile brands. Nobody really knows the name of the company. But once the media got attention of this critical statement, their treatment of the company and its inadequate social risk-based due diligence was detrimental to the company. So the company and the Danish textile sector have really understood how serious this is. The company hired a person to now deal just with this. And the Danish textile sector has been conducting seminar after seminar after seminar to try to understand about the due diligence that they are expected to conduct with regard to their supply chain. So I think that we can say that NCP statements can still change something, even if they're not legally enforceable, because they appeal to businesses in the language that they understand, which is reputational and economic losses and maybe loss of investors. So why do I mention the OECD guidelines in this context? Well, whether they apply to Greenland or not is actually an open question. Some people, and including Transparency Greenland, I know, has argued that because the Danish government did not make a reservation for Greenland to be covered by the OECD guidelines when Denmark acceded to the guidelines, they can be set to apply to Greenland. Others will say that Greenland, under the self-government setup, explicitly needs to accede to the guidelines, and this has not happened yet. But the point is that if we look at oil and gas, most multinationals or most large enterprises in the oil and gas sector are registered in an OECD country or in another country that has acceded to OECD's guidelines. So they should observe the OECD guidelines, and their home states have this obligation to remind them about the guidelines and about due diligence. And then when we look at good due diligence, we know that due diligence includes a meaningful stakeholder engagement in order to identify and prevent and mitigate and communicate on adverse impacts. We also see that, for example, China, which is not also not a member of the OECD, but has extensive minerals operations, also interest in the oil and gas sector, and I know an interest in Greenland, has actually issued its own guidance instruments for extractives designed to correspond to the OECD guidelines. And interestingly, I guess some of you will have heard that China sometimes has a problematic relationship to human rights, but they have actually issued explicit guidelines on human rights due diligence for extractive companies, only those operating outside of China, but that will be then the case in Greenland. So these guidelines do have some importance. And then I think I'll skip what they say, just put in this slide because I thought if they get shared in these, that's a nice, easy way to see what they say, because the OECD guidelines, I have to admit, probably the least pedagogically written international instrument that exists. Very, very difficult to read, actually. But NCP recommendations. Now, I mentioned the textile sector in the Danish case, but there are several mining-related cases that relate to deficient stakeholder engagement and result in recommendations from NCPs on how the companies should better engage in meaningful stakeholder engagement. We have the wind power plant in the Sami village, in which the village argued that yes, consultation did take place, but they didn't think it was meaningful. We have statements relating to minority investors, saying also that these have responsibility to exercise leverage. Now, oil and gas companies tend to be heavily invested by large as well as small investors. For example, there was one of the NCP statements relates actually to the Norwegian Bank for International Investment, which is the Norwegian Oil Fund. It is the world's largest investor. Obviously, there are a minority investor in a lot of companies. This NCP's case said that even minority investors have to use their leverage to argue that a company in which they invest should act socially responsibly and act with due diligence. So even minority investors, if they invest in a company that acts, say, wants to act in Greenland,
will have this, be under this expectation. Similarly, state-supported funding agencies like export credit agencies also have a responsibility to ensure due diligence by their funded companies, and state-based or state-organized economic actors, some of which there are a lot of in Greenland, are also subject to this expectation. So the bottom line here is that the OECD's guidelines are really an important normative source for both governments and companies. Here's also just a quick look at some of the cases. I'll skip those also, because yes. So I'm also just moving to the final slide. There are two elements in the conclusion, and one is that many companies, especially MNEs in the extractive companies sector, have CSR policies. Many of these have faced severe critique in the Global South. In the Global South, civil society organizations tend to be not as well organized as in the Arctic areas in the north. And still, this civil society critique has really had an impact in the Global South. I would imagine that most of the oil and gas companies operating in the Arctic would not like to have similar critique here. And at any rate, they do have the policies. So from the perspective of a government, there are opportunities for a government like the Greenlandic government to reach out to these companies, say, hey, you're already committed to CSR. You have this on your website. You have this, you communicate this on your annual general assemblies. We're certainly expecting you to walk your own talk. Now, when we talk about then impacts, as also Emma said, this can be adverse impacts, but it can also be opportunities. Under the OECD guidelines, there is an explicit provision under labor that multinational companies should try to use local employment, and they should also contribute to capacity building in the countries in which they operate. Now, from my chair, this would look like an opportunity that Greenland could also leverage in arguing impact-benefit agreements, even in addition to what's already done. Because, of course, the Greenlandic impact-benefit agreement is a really, really strong element in the Greenlandic extractive sector. But there is this opportunity to say, hey, you have this responsibility, this obligation under these guidelines to even think about the positive benefits. And then this that comes down to what about public participation and FPIC? And one of the things in here that I also discussed with some over lunch is that if governments, not just the central government, but also the local governments in Greenland, when social and environmental impact assessment is being done, reaches out to the population and really tries to ask for the local population's views of what, not just of what their concerns, but also maybe their dreams of what could be achieved when an extractive company comes in or a mining license is being put into operation for say, infrastructure or other activities that already occur. Maybe something else could be built. These companies, the large companies, they have huge resources for training in all sorts of issues, including occupational health and safety. They could maybe also use that for training people in other issues, like we were talking about alcohol politics, for example. So I think I'll just leave it at that and say the connection between law, politics, and economics is really much more complex, but also much richer than we maybe tend to think. And there are really huge opportunities for governments to call on companies to act responsibly by reminding them of the commitments they already have undertaken, and also to look at the OECD guidelines and UN guiding principles as additional normative sources, both for governments but also for companies. Thank you.
We really need our coffee now because it's getting late.